Hello, and welcome to this live webinar presented by Pierro, Connor, and Strauss, Paying for Long-Term Care and the Impact of New York's New Medicaid Home Care Rules. Just a few housekeeping notes before we get started. We're sharing our webcam and your mics are muted. This is an interactive program, so please have your mouse ready to answer a couple of poll questions and type your questions for the speakers into the Q&A section on the bottom of your screen. We'll try to answer those questions during the program, or we'll follow up with you. Today's presentation, plus our long-term care questionnaire, will be posted later today at the webpage pierrolaw.com/resources. And now I'd like to introduce our host, Louis Pierro, founding partner of Pierro, Connor, and Strauss. Hi, Lou.
Good morning, Beth. Good morning, everyone. Welcome to our webinar. Well, here we are again, talking about upcoming changes to New York's Medicaid program. And we have a bit more clarity now, and we have a starting date, as we're going to see, of April 1. So we're going to talk about a number of different things, and I'd like to introduce my co-presenters at this point. First, and certainly foremost in New York City today, my partner, Peter Strauss. Good morning, Peter. You need to unmute, Peter. And I'm going to introduce our other presenter, our senior associate and our Medicaid in-house go-to attorney, Mr. Frank Hemming. Good morning, Frank.
Hi, Lou. Thanks for having me.
Peter, we have your voice now, I see.
Yes, the audio was not working for a moment, but that's been fixed. Thank you.
All right. So we have 60 minutes, and we're going to cover a lot of territory. I just want to tell you a little bit about our firm. The Pierro, Connor, and Strauss firm, our main offices are in Albany, New York, and also in New York City. And we've had some growth. This chart has expanded since we last spoke with you. And you'll see new attorneys starting in New York City, starting with our partner there, Karen Kepler, who has come over with a significant experience in the tax and trust and estates area. We also have Harvey Schneider, who works with Karen and came over. They came from the same firm, and they have joined us effective January 1st. And here in Albany, I don't see him on there. There he is, Michael Godomsky, who has joined us here, and Michael is working in the special needs, litigation, and elder law areas. So we are a growing firm, and we're going to talk today about Medicaid, the agenda, cover what's changing. What are we expecting this year? And we'll give a little foreshadowing of what we think is going to happen based upon the federal election and the New York State budget, what the changes mean to you as an individual consumer or a loved one, or if you're a professional. We will be talking about that as well. The issue of the unknowns, things that we still are not certain of as the new rules are implemented, steps that you can take today if you need Medicaid home care, or if you want to plan ahead. How does this new rule both affect current applications and planning for the future? And then concrete steps that you can take once you know which direction you are headed. To begin, we're going to start with a brief poll just to gauge our audience. So if you could get your mouse out, as Beth said, and answer this: which best describes your need? Do you need Medicaid in the near future? Do you think it's something that you need within a few months? Does a parent or a loved one need Medicaid or may need Medicaid? We're going to talk about how to gauge that need as we go forward. Are you interested in planning ahead, getting your ducks in a row and making sure that you have a plan in place for long-term care? Or if you're a professional, we'd like to know that as well. All right, I think that should give you enough time. If you had your mouse handy, we could go to our results. We have a significant number of professionals and a number of consumers as well interested in planning ahead. So we will focus ourselves on those issues, and we're going to move forward on key questions when paying for long-term care. This is not a mystery. It's not fiction. This is science, and it's reality that as we age, we break down in certain ways. We may have physical or mental issues that require assistance. If we live long enough, the odds are that that's going to happen at some point in our lives, and longevity being what it is, that need now has a significant cost, and that cost is growing on an annual basis. We're going to talk about nursing home costs, but we're going to focus ourselves today on the cost of home health care. So if you do have that need, where do you want to age? Do you want to age in place, as most of our clients say they do, in the comfort of your own home? Do you want to look at a facility? Do you want a long-term care continuum, some type of continuing community? Or if you need assisted living or nursing home care, that may become a reality as well. Who would take care of you if this need arises? And finally, how do you pay for it? And again, there are only 3 real options to pay for long-term care. And you'll notice that one of the options that is not in the screen is Medicare. So we have to get that out right up front, that Medicare is not a payer for long-term care or long-term services and supports that you may need, whether it's in the community or assisted living or nursing home. So you first look to your own income and assets, and you have to do that in order to determine what your needs are. We'll talk about the costs in just a moment. But if you don't have sufficient income and assets, the next best thing to have is a private insurance policy, whether it be long-term care or one of the new life insurance policies with riders that allow you to access death benefits for long-term care. And finally, if you don't have enough in either of those buckets, then you will be relying on Medicaid. And that's why the cuts to New York's Medicaid program that began in October or are coming into full play this year are so critical and so important. So Medicaid in New York State, we're going to start there, breaks down into 2 different programs. You have the chronic care program, which is nursing home coverage. And New York covers significant amounts of nursing home care. I believe the number is about 75% of our New York State Medicaid or nursing home beds are Medicaid financed. And there's a 5-year look back. There are transfer penalties. We have planning techniques, even if you're in a nursing home or going into a nursing home, where you can save significant amounts of assets using something called the rule of halves and some of the other techniques that we're going to talk about. But those rules aren't really changing. The real changes come on the other side, and that is the community Medicaid program in New York. And New York State has historically been one of the most significant payors of home health care in the country. I sat on a governor's task force on long-term care financing way back in 1996. So 24 years ago, New York was spending as much per patient on home care as the next 11 states combined. And New York has continued to finance significant amounts of home health care. They also finance very limited amounts of assisted living. But the rule changes that began in October and are coming to us this year are on that side of the ledger. And so to get a handle on what this really means, I'm going to turn it over to Frank to lay the groundwork for the New York State Medicaid program. Frank?
Thanks. So whenever I'm talking, right, we're normally talking numbers because at the heart of it, Medicaid is usually a lot about numbers, how much you have, how much you make, and what we do with it. So whenever we look at Medicaid, we always have to look at income as one piece, assets as another piece, or resources on the chart. And it's important to kind of bring us all to head right now because we're in a new year. So when we get a new year, we get new numbers. So our numbers have changed just a little bit. So I'm going to do my best not to get these wrong as we get past this slide, just because the old numbers are ingrained in my head. So the new numbers, if you're one person living at home, you get $904 a month of income untracked. That's yours to do it as you want. If you're a couple, meaning mom and dad living in your house, and you both need Medicaid, now your new allowance under the new numbers is $1,320. That minimum monthly maintenance needs allowance, or the MMMNA, goes up to $3259.50 per month. That essentially is how much a community spouse can have of their own income if their spouse is in the nursing home. Okay, so that's gone up just a little bit. And then our asset numbers have also gone up just a little bit. Our new numbers for those, if you're one person, up from $15,750, we're up to $15,900 for one person. For a couple, it's up to $23,400. And then that community spouse resource allowance still stays at $74,820. There is an increased spousal share, but when these new rules take effect, that's going away. So it did go up just a little bit, up to $130,380, but that's ultimately going to go away. So I'm not going to spend any real time on it because it's legal.
So that has been a peculiar rule in New York, and that came in under Governor Pataki, where they increased the spousal resource allowance, but only if you had resources greater than 74,820, up to basically 2x, twice that number, you could get an additional resource allowance up to that 130,380. New York eliminated that and actually simplified the rule, capping it and locking it at 74,820 for that spousal allowance. And that's something that they were trying to get down to $25,000, but there was a lobbying effort by the Bar Association and others, and it locked in at 74,820. So that's where we have the spousal resource allowance.
So we're going to be talking a lot about penalties and ineligibility and all that good stuff. So we figured it was a good idea to show kind of an example of what the penalty means and how you calculate it.
So Frank, before you go into the penalty,
Sure.
talk about the look back period, because most people confuse
All right,
these two.
sure.
And just to clarify that.
Yeah, sure. So when we're dealing with Medicaid, right? So if we're doing nursing home or we're doing home care under the new rules, so not immediately, but coming soon, if there's a look back period and you have to deal with one of those look back periods, what that means is that you have to take all of the financial data that you've had during that period of time. So it's going to go back to October 1st, 2020, if you're applying for home care once the new rules take effect, or the last 5 years for a nursing home. What happens is the county looks at all your financial information and they look at how much you've given away or transferred out of your name without receiving any real benefit for it. Once they find out all the amount of money that you've given away, they total it up. And that's what this example is showing. So in our example, let's say in the past either 5 years for nursing home or back to October 1st, you've given away $140,000, $142.68. That's what you've given away. What they then do is they take that total and they divide it by the applicable regional rate for where you're located. So the one in front of you, that 11,689, is the regional rate for the Albany area, just because that's where our office is. So if you run those numbers, and
these are the rates.
The updated numbers are now on your screen.
So there's your 2021 numbers for the penalty period calculation if you have transfers within the look back.
So since we're in Albany, we took the Albany number, we take our total amount we've given away, we divide that by the penalty number, and we've come out to 12 months. So what does that mean? If we do all of our planning for home care and get our application done and submitted before April 1st, as we're going to go into, no penalty. That's one of the big things of why we want you to do your planning now or get your applications in if we need to do that. If it's nursing home or after April 1st for home care, you're going to get hit with a 12-month penalty where you're going to be private pay for your health care until Medicaid starts to pick up those costs for you.
So these are all rules that have been imposed to put traps in for the unwary and the unprepared. And when the rules changed for nursing home care, they changed in 2006, and they changed the rules so that you couldn't even run the penalty period unless you were already in a nursing home, you were otherwise eligible, meaning you were down below that $15,900 number, and you actually file your Medicaid application. That's what starts the penalty period running for asset transfers within that look back period. Remember that when we start talking in a bit about the Medicaid home care rule changes, because now we have similar concepts for home care, which didn't exist before. And the rates, we showed you this a minute ago, you'll notice that the downstate rates are higher than the upstate rates, 13,000 and change. These are not the real costs of care, although the state uses these to emulate the cost of care, because it's supposed to be 1 month of care. And if you look in that 11,600 and change number in Albany is not close to the private pay rate, which is really, Frank, about $15,000 or $16,000 per month. And
Right,
Peter,
and in the New York City metropolitan area, you're talking maybe $15,000 to $20,000 a month. And if unfortunately you need a ventilator, the cost is, and there are very few nursing homes that have them, it could be $30,000 a month. So we're talking about significant costs and anticipation of greater costs.
and the misconception that a lot of people have is that, well, if I have home care, that's actually going to cost a lot less. And that could be true depending upon who's providing the care. If it's your daughter, then it's going to cost a lot less. But if you need 24-hour-a-day professional care, it's actually more than. the cost of a nursing home. Nursing home costs here about $180,000 a year. We have clients with 24/7 home care paying $260,000 per year for 24/7 home care. So we're talking about, as Peter says, the most confiscatory tax we have is the long-term care tax, because it's $260,000 a year and it's going to drain your accounts until you're bankrupt. And so when we look at home care, Peter, these new rules are now going to play in.
Correct. And the statute, when passed, was to take effect October 1st of last year. But because of a variety of reasons, including, I think, the effect of COVID and some federal regulations, it's been postponed to April 1st. Let me just say before we go into the weeds here that this is a shocking change in social policy in New York State. New York was at the forefront. If you talk to family members in other states and you would tell them that you could have transferred your assets to a child and get Medicaid home care the following month, they would say, no, that's not possible. You're getting wrong advice. And the answer was no. I heard it from Louis Pierro, and it's the right advice, and Frank and Peter. So why did this happen? It happened because the substantial portion of the New York State deficit is from Medicaid, and the cost factors, and it's going to get worse because of COVID. So this is a big social policy change, and we need to think about that from the broader perspective. But now the new law is going to take effect on April 1st. We'll talk a little bit later about what we can do before we get to that date. But it's going to be pretty much fully implemented on April 1st. And it applies to all the home care programs. And one of the big changes, other than the, Lou, did you want to jump in?
Yeah, so far, Peter, it appears that the nursing home transition diversion waiver program is not covered. And
okay,
so,
well, that's good news, right?
Yeah.
But there are some other big changes. It used to be that your biggest ally, other than your elder law attorney, in filing an application and getting what you needed was your treating physician, because the agencies had to rely to some extent on their opinion. And if you didn't get the hours you wanted and you went to a hearing, an administrative hearing, to get more, the testimony of your treating physician would be extremely helpful and enabled us to be victorious in most of our challenges. That's not the case any longer. So one of the things that in effect is a way to limit access in terms of number of hours is there going to be the requirement that an independent physician, not the one that knows you best, is going to be giving the number of hours recommendation and writing the prescription. And that applies to post-personal care and the consumer-directed program, which we'll talk about in a minute. Secondly, the assessment is now going to be done by an independent assessor. That's probably going to be through the firm called Maximus that's been doing a lot of this work for the state on a contractual basis up till now. But are they really independent is the question. And you don't have your best witness available to help you out. So getting you the number of hours that you need is going to become more complicated. And this is also budget driven. They didn't do this just because they want to harm you, but that may be the effect. And that will take effect on April 1st. The other thing that's there, in addition to the lookback period and the imposition of penalties for transfers, is the ADL requirement, activities of daily living. It used to be that you would qualify if you couldn't perform 2 of the activities of daily living. Now it's going to be, you'll see, more than 2, meaning 3+, with some exception for persons with dementia, including Alzheimer's disease. That's not going to be affecting people who are already on these programs, either getting personal care aids or a consumer-directed personal assistance program. The acronym is CDPAP. Those programs still exist, but access is going to become more difficult. So this shows you what the ADLs are. The classic ones are in the box on the left. Now there are some additional ADLs that are going to be considered. We think, we're not 100% sure. Frank, have we heard any late word on this? Are they going to be added to the 8 in terms of ADLs?
I haven't heard anything concrete here.
Yeah, so this is another area of uncertainty. So stay tuned on this.
And Peter, these new rules are clearly designed to limit access to Medicaid home care and to eliminate the rights that people had to pursue fair hearings if they got denied the care that they thought they needed. Because we're losing the position, we now have an independent assessor. And if you go back, this whole panoply of rules was churned by the Medicaid redesign team part 2. And that was because of the $6.2 billion state deficit last year. Medicaid redesign team 1, if you remember back, brought us managed long-term care. And the managed long-term care program was what was supposed to be the control of what was being spent with creative managed care to bring the triple aim: better care, better results, and lower cost. That never panned out. There was a report done by NALA, the National Academy of Elder Law Attorneys, the New York Legal Assistance Group, and a series of others that was entitled Mismanaged Long-Term Care. And what it showed was when people pursued their rights at fair hearing, they won 99% of the time. And that result in that report, I believe, was partially responsible for these new rules eliminating virtually the underpinnings of your case at fair hearing. The other one that is giving us great concern is this safety monitoring, because now there is a rule that says safety is a potentially limiting factor for people who require more than 12 hours a day of care at home. So the question becomes, can they reassess? Are these new rules going to be applicable on reassessment for existing Medicaid recipients? And the answer is, for most of this, no. However, the safety monitoring issue gives them a reason to go in and reassess the amount of care being provided. And if someone is receiving 24/7 care at home and they determine that they're not safe to be at home, Peter, where does that land?
Well, it's serious. They're basically saying, listen, if you need more than 12 hours, you must be so sick that you're not safe at home. And we don't know the implications of this. And, add to it what happened a few years ago as a result of the Medicaid redesign team and managed care. If you didn't get the number of hours, we could go and do an administrative fair hearing immediately. But under managed care, you had to do an administrative appeal within the very barn that, had locked up the horse. Now the horse is out of the barn. So the people who said no initially is the ones you have to appeal to under managed long-term care. It's going to cause delays, and you may not be successful, because if we go from the administrative hearing where you get denied to the fair hearing officer may not be as inclined as formally to give you the number of hours that you want. So when you add this all up, there's great harm to the older people in the state of New York. We are no longer the wise people of providing care to people who are middle income and poor.
And the budget deficit for 2021 is projected at $15 billion, and last year was 6.2. So we'll see with the new administration. I mentioned that the election has a great impact on all of these things, because one of President-elect Biden's proposals is to expand home care services and to expand the ability to care for our seniors in their own homes. We'll see if that results in aid to the state, which could then reinforce and bolster some of these programs. But New York State can't print money. They can't just close a $15 billion budget gap by printing new money and borrowing. They have to balance that budget. So we'll see in the governor's budget, which is due out very soon, where those cuts are going to come to get that $15 billion for 2021. But these rules are clearly designed to reduce the Medicaid budget in New York. So the key dates, the dates you have to know, October 1st is the first date. And on October 1st, that's when transfers began to be penalized for home care purposes. That has not gone into effect yet, but any transfers made on or after October 1 of 2020 will be subject to that look-back period. So when they do impose the rules, they'll start the imposition on April 1st of 2021. There will be a 6-month look back going back to that October 1 date. The next month, it's a 7-month look back. So we will hit the full look back 30 months from October 1 of 2020, which will be April 1 of 2023. That's when this will be fully in effect, and there will be a 30-month look back. It expands 1 month at a time up until then. There is legislation to clarify some of these rules. Obviously, the legislature hasn't been in session. They are now. So this will take time for any of these legislative solutions to percolate through the session. Typically, these kinds of things aren't dealt with until toward the end of the session, which would be April, May, June. But we'll be tracking it, following it, and bringing you more information as that changes. There are certain existing Medicaid rules that will stay in effect even after the imposition of the changes to community-based Medicaid. And Frank, walk us through those.
Sure. So we use these now. We're going to use them in the future because they're not changing, and that's a good thing. So if we have one spouse that's alive and needs care and one spouse that's alive that doesn't, we simply transfer assets from the ill spouse to the well spouse. And then we get the ill spouse Medicaid. They become the Medicaid recipient. We also have a few other people you can transfer to. If you have a disabled or blind child or a trust that benefits such a child, you can freely transfer to that child or that trust free of penalty. So one thing that we always ask clients when there isn't an alive and well spouse is, do you have a disabled child? Because if you do, that opens the door for a lot of planning opportunities with no penalties. You can also transfer to a trust established solely for the benefit of an individual who's under 65 who is disabled. This one is just not as preferable as the two above, just because those sole benefit trusts do have payback provisions in them. So it gets you some benefits now, but you kind of have to deal with losing benefit or losing assets later as the state gets paid back.
But I would point out that even though there is the negative of the payback, if you were to transfer assets to a disabled child, you're not penalized for your Medicaid, but that child may be on Medicaid or SSI. So we may be forced to use the trust. Sure. And the payback doesn't occur till that child dies. So maybe we use that money up before that child dies, but that's a secondary concern. The primary concern is protecting the client who needs Medicaid now without the harmful effect on the child with disabilities.
Sure, it's a very good point, Peter, thank you. So what other things can we do? What other remedies do we have? If transfers have already been made, what can we do or how can we justify those? So one way that we justify a transfer that's already been made is to say that you actually got full market value for that transfer. Because then essentially it's not really a transfer for Medicaid purposes that would result in a penalty if you got back value for that transfer. So sometimes where we see this is, for instance, if you paid for a home repair, but you paid the repairman in cash, right? That's presumed to be a transfer. But if we can then produce an invoice or something from that contractor saying, no, they paid for something, that eliminates a transfer. You didn't transfer something free of benefit, you got that benefit in that example. If you, another one that we don't use often because it's difficult to prove, but if the assets were transferred exclusively for a purpose other than to qualify for Medicaid, there is existing law on the books that says you cannot be penalized for that. The issue with this is, how do you prove it was done for a purpose other than to qualify for Medicaid? Depends kind of all on the circumstances of what we see in that case. If you were alive and well and had no reason to think you were going to need Medicaid anytime soon, that's a very strong factor in your favor that you didn't do it for Medicaid planning purposes. If you were told you need a nursing home tomorrow and you gave everything away, you're going to lose that because they're going to know that was really to qualify for Medicaid. That's why we put that bottom bullet. If the burden is met, the transfer is exempt, but it's on you. You have the burden to prove that you meet one of these exemptions. So that's why we always have to make sure that we build a strong case.
And the form for that, again, is an administrative fair hearing where you go in front of an administrative law judge and they have you on the phone and they record the session and they write a decision based upon the recording. But that administrative hearing can go in any direction depending upon the judge and who you have on the other side of you. So these are all fact-driven cases and you have to prove them.
Yes.
And it's, as we say in the law, it isn't what you know, it's what you can prove.
And then the last one here, which is one that I think we probably use most often of these, is if you gave something away, but it can be given back to you, then we have the person give it back. Because if you get it back, then you didn't give it away. The issue then becomes if you receive that asset back, now we have to plan for it because now it's back with you. I know you're going to be limited to that 15,900 or 23,400, depending on if it's one or two people applying. But that kind of gets us further down the road where now we don't have a penalty issue to deal with. Now we have an asset issue to deal with.
Just want to unpack that first bullet a little bit further. We have people come in quite often where they've given money to their children. And they may give $15,000 per year gifts, which is a tax law concept. That does not translate to Medicaid. Medicaid doesn't have any $15,000 per person per year exemption. Medicaid will allow you to pay children for services. So if a child is performing services for a parent, we prepare a contract, a caregiver agreement, which details those services, puts it into a contractual format, so they're obligated to provide the services, in which case payments to them can be justified. But we also have a lot of people who come in and the children say, well, you know, I've been doing things for mom and dad for the last 5 years, and yeah, they gave me a bunch of money, but can I just call that being paid for my services? When you're doing it without the original documentation, and it isn't consideration, it's just gratuitous transfers that happen to coincide with some things that the kids are doing, that's not going to be a winner at the fair hearing. So there are ways to do this right if you plan and prepare and document your case, but these are remedies that require fair hearing, and you never want to be in that position. That just means that you haven't planned properly. Peter?
Okay, so one of the problems in Medicaid in New York and in most states is that, as you saw earlier, you're only allowed to keep, if you're on Medicaid, a certain amount of income per month. And I think the number this year is going to be 905 or 904, as we saw earlier. Suppose you've got $1,904. That excess income of $1,000, theoretically, you're supposed to contribute to the cost of your care. Share of costs, spend down are the terms you will normally hear. But there's been traditionally a way around that. New York allowed you to put that excess income into what's called a pool trust. That's not a tax term, although there is such a thing for taxes. But the Medicaid law says that a trust established and managed by a not-for-profit organization where you as the beneficiary of Medicaid has an account can take that excess income, you transfer it into the pool trust account on a monthly basis, and that could be spent on your care and you wouldn't have to spend it down by giving it back to the Medicaid vendor. That's changing to some extent. We're not quite sure how it's going to be working, but it appears that the new statute says, sure, you can put it in the pool trust and you won't have to give it back to us, but you have to spend it in the month you put it in the pool trust, rather the trustee of the pool trust does. Now that obviously raises all kinds of complications, including administrative ones. I mean, think of the burden on the Medicaid agencies to monitor this. So it may be that they're going to do it on an annual aggregate basis and see if all the money you put in the pool trust has been spent by the trustee on your care, and anything that wasn't spent, they may make you give back to the vendor or to the Medicaid agency. We're not quite sure this is how this is going to play out, but that's another hardship here and another cutback in your ability to make the Medicaid home care work. So here, this is what this tells us. And it also tells you what the pool trust can do. It can pay for your food, your rent, your mortgage payments, computers, technology to help you stay at home, which we'll talk about a little bit later. But this is another serious problem. So what you're seeing here is a pattern of new restrictions from what we've already talked about in this one that may well force people not to get home care benefits. Where are they going to live if they don't have a spouse or a child nearby? The neighbors are going to do some things. They'll do your chores, but they're not going to become your caregivers. So we may see serious problems for this community because of these new changes.
Yeah, living on $900 a month is not a feat that almost anyone can accomplish. So the pool trust has been a lifeline for people who are living in the community and need Medicaid to support them because of their chronic illnesses. We believe that the pool trust will stay in existence and the income contribution will be continuing under the new rules, but we're not quite sure yet how that spend down requirement is going to play out. So let's take a look at today as we sit here in January 7th of 2021. What can be done to qualify for Medicaid right now? And we still have all of the same tools available to us that we've had, as Peter said, in the most generous state in the country. Well, the most generous state in the country exists for another 3 months, and that's it. So we have the ability to transfer assets today, apply for Medicaid prior to April 1st, and qualify immediately for Medicaid services. No look back, no penalty, no complicated calculation, which we're going to get to next. And so we have the ability to keep $15,900. We can use the pool trust to shelter income over the $904 per month. We can transfer to a Medicaid asset protection trust. You can always spend down, as Frank said, transfers for value on legitimate items. And we always crassly say, well, remember, your lawyer is a legitimate spend down item, so your legal fees are covered. Not a bad thing for us. But you can transfer to spouses, disabled children, all of those things still apply to get Medicaid right now. Let's take a quick example. If we have here Evelyn with $2,370 a month of income, she has an IRA of $75,000, she has checking and savings of $25,000, she owns a home of $250,000, and she's been able to build up a little portfolio of stock of $100,000. The question is, when can Evelyn be eligible for Medicaid home care if we start planning on January 7th of 2021? And I know these guys know the answer. And it's an answer that surprises a lot of people. And the answer is February 1st, because we can transfer things. And Frank, how does that happen?
So we do a few steps, right? As I kind of alluded to at the very beginning, we look at assets as one piece, we look at income as another piece. So we first shelter her assets. We create and fund a Medicaid Asset Protection Trust, which Lou and I will talk about in just a bit. We put in her home, we put in that stock, we put in some of her cash because we got to get her down below $15,900 of assets. Once we do that, then we create a pooled trust that Peter just went into detail about. We assign all of her excess income to that pooled trust. Once we do those two things, we're down to $15,900 of assets, income of $904. We submit that Medicaid application to the local county Department of Social Services, and we get Medicaid real fast under the current rules. No waiting period, no penalties, all the good stuff that we've been able to do for a long time.
That's with your own treating physician, preparing an affidavit, supporting the home care number of hours. That's with an assessment that we know is going to come from Maximus and the MLTC, unless it's nursing home transition diversion waiver or immediate needs. We'll get to those later. All of the existing rules apply to that application, and we can do the asset transfers. This is current law, and it's still good, but for a very limited time, Frank.
Yes. Essentially, because we have this April 1st start date of all the new changes, right? If you have to apply for Medicaid, Medicaid looks at what you have on the 1st of the month. So if they look at what you have on the 1st and you have to apply within that month, then the last time we can apply for you is your application must be filed with the local county by the end of March. So March 31st. What does that mean? That means your transfers are done by February 28th. because we want you to be eligible as of March 1st. That's the last chance we have before we get the new start, all these new things. So that's that limited time.
So today, the primary way that you would do planning, whether you're immediate need of Medicaid or if you're planning in advance, is to utilize a trust. And this is a specific type of trust that we've been using since 1993. Literally, these laws have been with us since 93. And we created, yes, it's an irrevocable trust. We'll get to that in a minute. You put the assets in, you can keep the income from the trust. You keep the right to live in your home. Keep your STAR exemption. From a tax perspective, this is a neutral. It doesn't change any of the tax implications of any of your assets or income or your home. You have heirs ultimately upon your passing that are going to receive the remainder of the trust, what's left, and that includes the home and other assets. And again, from a tax perspective, they get it with a full step up in basis so that they inherit it with a fully stepped up basis, any capital asset that has appreciation. All good stuff. It avoids probate. It's a very, very sound, secure trust. We doctor it up a little bit. So we've been, over the years, continuing to evolve our trust document. And Frank, when people want to protect assets, what do they put in?
Mainly their home, right? That's one of the very first things we talk to you about. Do you own your house and do you want to protect it? We put in bank accounts, we put in stocks, we put in annuities, as long as they're not tax qualified annuities. We put in life insurance if it has a cash value. If you are a business owner, we put your business in there. We have other real estate, so you have that family camp or a rental property. We put all those good things in there. The things that don't go in there are, we don't put all your cash in, right? We just talked about some of this. If you can be on if you need to be on Medicaid, you get an asset allowance of $15,900. Now, we don't want you to feel like you need to not have any cash in your name. So we have a discussion with you and we find out what's a good place to put the cash where a lot of it's protected, but you also have plenty to use on your own. The other main asset we don't put in here are your retirement accounts, those IRA, 401k, 403b, 457 plans. Anything that's a tax deferred retirement account does not need to go in here because under the Medicaid rules in New York, they're already exempt once they can be exempted once they go into periodic payment status, which happens by law when you hit 72. So there you go.
So that is a very important feature of New York law. If we go 15 miles from Albany or 10 miles from New York City into New Jersey or Massachusetts, IRAs are not exempt. They are countable assets and have to be dealt with. But in New York, they're exempt assets. All you have to do is draw some income from them and you can exempt the IRA 401k. Great. These assets, this list goes into the trust. You keep the income again. The principal cannot come to you directly. That's one of the rules. We cannot make principal available to you directly. But if you have children, principal can be distributed to the children who can in turn pay bills on your behalf. So we can keep access to this through the kids. Now, the two big hurdles that most clients have to get over to use this type of trust is, well, I'm not going to be my own trustee and I don't have direct access to the principal. So when we design the trust, we design it typically with the kids as trustees or some trusted individual, brother, sister, niece, nephew, who you're going to have as trustee. You can always change them. So if the trustee isn't doing exactly what you need them or want them to do, you fire them and you replace them. You put in a new trustee that will do what you need. You also have increased leverage because at any time you can change who those ultimate beneficiaries are. So you change trustees, you change beneficiaries, and under New York law, there's a provision, the State's Powers and Trust Law section 7-1.9 that we utilize that allows you to revoke an irrevocable trust with the consent of the beneficiaries. And if you think to yourself, well, if I can change beneficiaries and revoke a trust with their consent, I still have a pretty good amount of control over this trust. So we're getting people at younger and younger ages who are utilizing this trust because of all of those security features and the flexibility in New York. Plus, you keep your 401k IRA outside the trust. It's already exempt. Enough bank accounts and cash that you're comfortable. This is just a little flow chart. We have these trusts today. We may not have these trusts when the next round of Medicaid cuts go into effect. So if you're contemplating planning or you need Medicaid right away, as we say, get it done in 21. The time to act is now.
Let me just add one caveat. People should remember that, yes, it's true, the IRAs and retirement funds are exempt if you're in payout status, but listen to that term, payout. There's now cash coming out that adds to your income. And remember, you're limited on your income. So that extra income gets added to the other excess income that probably has to go to a pool trust. That could raise problems if you have a very good retirement monthly payment at the end of the year when they calculate whether there might have to be a give back to some of that money. So just keep that in mind.
So Frank, because of the delays in processing Medicaid applications, the county has 45 days to make a financial determination. You then go to Maximus for evaluation. You then go to the MLTC for an assessment. And very often we see these things taking 4 to 5 months before actual benefits are turned on. In response to that lengthening time period, New York enacted something called the Immediate Needs Program. How does that work?
So it's a limited program, right? And I think that's important to say because it's a great program in practice. It's just difficult to qualify for. So Immediate Needs is a program that every county in the state has, and it basically fast tracks the application. It says that the county has to process and approve that application basically within 19 days. And the county will step in for that managed long-term care company, and they'll start assuming the care and getting care in place as quickly as they can. The problem or the main issue with this plan and this program is qualifying for it, because you have to basically say through affidavit and through medical evidence that you need help now and you don't have anyone to provide it for you, right? If you have that child that's helping you, you don't qualify. If you're private paying for care already, you don't qualify. If your needs can be met through specialized equipment or other things that can be modified to your home, then you don't qualify. And you also need your doctor to attest that you need all these things and to put in writing that you need all these things. So if you meet those limited circumstances where you need help now, you're not safe without it, and you don't have people or means to provide it on your own, you can get immediate needs. And when we can, we utilize this program all over the state. This just puts in writing some of those timeframes that Lou already mentioned. I'm going to add one additional conflicting factor that complicates things now, and that's COVID, right? I'm wearing a mask right now. Many counties now are operating at a 25% staffing level again. So what that means is we have all these people that are filing these applications, and now we have county workers again, for the most part, still working, but a lot of them are working remotely again. So that we are seeing increased delays in a lot of places when more in the summer, we were seeing things processed very quickly, because one of the few advantages COVID has given us is that to protect people and to get care in place sooner, people are allowed to to attest to their resources a lot easier and to have things attested to rather than proved for some of their asset things if they can't get documentation. We are starting to see the delays again. Just wanted to mention it here.
So I'm very bullish on the immediate needs application. If it's a close call, we file it as immediate needs because you get such an expedited time frame. This is a determination made by the county. So the county is going to do the assessment, not the MLTC. And it's in many counties, they're very welcoming of people who are in need to get that application processed faster. So that is something to be aware of. Let's turn now for the last 10 minutes to what you can do come April 1. What is this law going to look like, and what planning tools will we have available to us? And we've basically broken it down into 4 categories. We still have, as we do for nursing home care, the ability to loan money out and gift money at the same time. Start the penalty period by applying for Medicaid. You have to prove that you're otherwise eligible. And then that penalty period will run while the note pays back. Frank's going to talk about that one, along with a gift of 100% of the assets, and that gift back that you mentioned earlier. You can simply wait it out. You can transfer assets, create that Medicaid Asset Protection Trust, and plan to private pay for 30 months. That's another strategy depending upon how much you have in assets. And then Peter's going to cover the spousal refusal. Frank?
All right, so I'm going to try to just make this simple because this is a complicated planning technique that we've used for a long time in nursing home cases, something very similar to this. So first, option we have is we use a gift and promissory note plan. So let's take someone, they've got $249,000 of assets. We allow them to keep their $15,900 exemption amount. Then we do a calculation and we come up with roughly half the money getting gifted away from the person to their family. And that's basically the family's inheritance, or that's more money to use for the Medicaid applicant for their expenses and their other needs that Medicaid isn't going to cover. When we give things away, what happens? If there's a look back period, you give things away, you get hit with a penalty. So we take the other half of the money that we leave with the applicant and we loan it to the family. That then pays for their care during the period of ineligibility while that penalty period is running. So if you look at the numbers on our screen, when you take all those numbers, you crunch them up, you use the penalty numbers, it comes out to a 10-month penalty if you give away $116,890, and then we loan the other half to the family, where they then pay for that 10 months. That side account that we mentioned, that's used by the family to pay for other expenses, right? It could pay for things with the home. It could pay for the utilities, the upkeep in the house, all those good things. The other feature of this plan is we do a trust to protect the things that we leave with the Medicaid applicant. So if we leave their house in their name, we create a revocable trust, put their house in the revocable trust, we put that $15,000 in the revocable trust, with the main reason being we don't want any estate recovery or probate issues when that Medicaid applicant does happen to pass away.
So Frank, the nursing home application using this technique
Yes,
is fairly routine at this point.
it is.
It didn't exist before 2006 when we got those changes to the Medicaid rules. But the promissory note, the loan, and the gift is something that we do routinely. But think about this. You know that the nursing home bill is $15,000 a month, so you can budget that into the calculation.
Yes.
Home care costs are much more variable. So you have to build in some flexibility because the cost of care during this time period may go up or down, and you have to hit the target.
Yes.
That's why you have that side fund. And some people use just the gift back rule, and that's what the next slide is.
Yeah, so essentially, instead of doing that whole promissory note plan where we do the calculation, we split everything up, we earmark some to be paid back to the Medicaid, or to pay for private care, we earmark other parts for the family. This one, we just say we're going to keep everything we can with the Medicaid applicant so that it qualifies. So that's that $15,900. It's their residence or their exempt assets, and then we're going to gift everything away, and we're going to give it to the kids. And then the kids, once they have it, they're free to do planning with it because now it's their money. So they can create a trust, and then in that trust agreement, they can lay out these funds are to be used for these things. It could be used for mom or dad's care if they need it. And it's just another strategy to get things away from mom or dad, get them qualified, and then the kids have the money to help deal with the penalty because we gave all that money away, still while protecting against asset recovery after the Medicaid applicant passes away.
All of these things are going to require very careful bookkeeping and accounting because when we go to apply for Medicaid, they do a full analysis and a full audit of all of these transactions. The simplest of these is transfer and wait. So you give away the assets, you create your Medicaid Asset Protection Trust, you keep enough to pay for care for that 30 months. And remember, if you need to, you can always draw from that Medicaid Asset Protection Trust by the trustee gifting out to kids. If you run out of money for that 30-month time period because the cost of care is escalated, you could certainly either draw from an IRA or draw money from the trust of the kids who could supplement until you get to the 30-month time period. But this is what we call a transfer and wait scenario, where you're going to keep enough money, spend it down, and then have the application filed at the end of the 30-month time period. And Peter, we always have our old friend.
Yes, but I want to comment on the other three plans, because to the extent that they involve some period of ineligibility where you're going to have to private pay, this is where long-term care insurance should come in, because the long-term care insurance, even if it's a hybrid, may help you bridge that period and help pay for that period of ineligibility when you're private paying. So keep that in mind. Now, the last plan is what we call spousal refusal. You'll recall, as Frank said, that transfers to your spouse are not transfers that cause a penalty. You're allowed to do that. Now, to some extent, the assets that you transfer to your spouse is protected by that community spouse resource allowance, and that number will vary. But suppose what you transfer to your spouse brings your at-home spouse above that sort of protected amount. What's the consequence of that? Well, your spouse could become ill later on, and now we have another Medicaid planning issue involved. But also the state may seek to go after the at-home spouse for support because there's still a legal obligation for one spouse to support the other. To what extent the counties are going to do that depends on where you're living, what the county's policy is. Some counties apply a rule that says, well, if you give us 25% of your income, we'll leave you alone. That happens a lot in New York City. But to some extent, the spousal refusal, which is a legal right that you have under federal law, can not be a perfect solution. So this is something that we have to watch on a case-by-case basis, and we will counsel our clients about the likelihood as best we can about whether that is a significant issue.
So to recap, if you're not applying for Medicaid immediately, you don't have the need for home health care. The time to plan is now. Planning to pay privately would include managing your resources, managing your income, doing some tax planning, and marshaling your resources to come up with a $15,000 to $16,000 a month payment. And if you fall short of that, as Peter said, consider buying insurance now to fill the void, to bridge that gap. At least 30 months of insurance to get you through the home health care period, to get to Medicaid eligibility. We believe very strongly, more so today than ever before, that private insurance has a valuable part to play in any of this planning because government resources are scarce and becoming more and more limited as the population ages. Planning to access Medicaid would involve the Medicaid trust that Frank and I went through. We do these on a day-to-day basis. We do a lot of them, and they work extremely well in the right cases. So every situation is unique. What are your next steps? If you think you can qualify now, the first thing we really have to do is get an assessment to determine whether you're going to be eligible for Medicaid. We work very closely with Ever Home Care advisors, Nora Barato and Susan Vale, who are two very experienced geriatric care managers. They go to homes and do the assessments in advance of our applications so that we are not throwing spaghetti at the wall. We are targeting like a laser beam specific services and applying for specific Medicaid services based upon their very thorough assessment. If you're going to need Medicaid now, you need to get all of your transfers done by the end of February, Frank, because it won't do you any good in March.
No, if you transfer in March, then the first day we can apply is April 1st, and then we're in the new rules, and that's not what we want.
So everything has to be in place. You can get an assessment done. In New York City, we have people that we can refer you to as well to get that initial assessment, to know whether you're going to qualify in advance before you do the application and know what you can qualify for, and then get your transfers done by February 28th and get your application in then in March before the April 1 change. If you're looking at planning for the future, Peter, we always begin with a very substantial analysis of a person's personal, financial, and legal situation.
Absolutely, and here's where it makes a lot of sense. Just after listening to this program today, go to your financial planner, go to your accountant, do an analysis of your future needs, your costs, and make sure that that analysis includes the possibility of a need for paying for long-term care costs. So that's really important. Talk
And
to an LO attorney.
Beth mentioned earlier, we have developed over the years a very comprehensive questionnaire that threads right into this topic, the long-term care plan. That's going to be available to you along with the slides on our website later today. So check for that posting. Beth will be putting that up, and we would be very happy to talk to you about that. We have a brief poll to conclude here. And if you would like to have a virtual consultation or a phone consultation or an in-person consultation, let us know. We'd be very happy to meet with you. If you're a long-term care professional, I think many of you are, would you like to have a conversation with us about how we can collaborate with your clients on planning for long-term care and accessing Medicaid. Would you like more information? We have a long-term care planning guide that we will be issuing for 2021 with all fresh numbers, all of the new rules. We're updating that as we speak, and that we'll make that available to you. So let us know if you'd like to get that when it is finalized. And if you'd like more information about our annual Elder Law Forum, which will be coming up in May, that's our signature event. We'll be covering a lot of these topics in great detail with a multitude of speakers. Let us know that as well. All right, so let's conclude. And I will take back the screen and move it to, there's our contact information. So if you'd like to have a consultation, give us a call, send us an email. If you'd like to get more information, info@pierolaw.com.